in Article 3, in Marbury versus Madison, John Marshall famously said it is the job of the judicial department to say what the law is. But the two most prominent legal philosophers of the day, Blackstone and Montesquieu, both said, no, that is the road to despotism. And what he left out in his Marbury 10,000-word decision was that in Article 3, it gives Congress the specific power to change jurisdiction. For people who grew up in the 60s and 70s and 80s, they think of the court as, well, this kind of a liberal bastion. The Miranda decision and Baker versus Carr and Roe. But in fact, for almost all of our history, the court has been the defender of the status quo. Congress's lack of action is partially because the court wasn't a threat. The court was maintaining a status quo that Congress actually approved of. The 14th and 15th Amendments were extremely unpopular even in the North. Then the Civil Rights Act of 1875, which allowed free access to theaters and public conveyances, was immensely popular. So when the court declared the Civil Rights Act and the civil rights cases in 1883, everybody was kind of happy. Now we have a very different situation where the court and much of the government has moved away from what the people want. And the legislature, unfortunately, is reflective of that conservative bent. So part of the reason that the legislature kind of abdicated its responsibility or punted the kick the can down the road theory of government is that the court reflected what they wanted for much of our history.